Good morning, everyone. I hope I am audible to all of you, and welcome to a new session of the Indian Constitution. So, in the last class, we have talked about various things like we have talked about the Supreme Court of India. That was a very important topic which we had studied in our last class. But today we will try to finish this judiciary part as soon as possible, because there will be another chapter which needs to be covered. So I will be trying to finish the topics which has been covered till now. Okay. So let's move on as very fast. Let's move on to this today's topic. Today we will be talking about the High Court of India. So last class we have talked about what? We have talked about the Supreme Court. Okay. So Supreme Court has been done. We have talked about Supreme Court's various jurisdictory powers and everything we have talked about them. And today we will talk about the High Court. So as we already know that we have got, if we talk about the hierarchy of our judiciary, then we have got what? We have got a Supreme Court. Then the second we got the High Court. And if we talk about the third, we get subordinate courts, and subordinate courts and district courts that will be done in today itself, but in the another chapter. But before that, if we talk about our High Court, then High Court is just below the Supreme Court, but above the subordinate courts. Okay. So if we're talking about this lies in the middle of subordinate courts, that means what we are going to, where we are going to, and the High Court, which is and Supreme Court, which is the topmost priority if we are talking about. So that gets the topmost priority in our judiciary system. So if we talk about the state administration, in the state administration, the High Court occupies the top position. So if we talk about the Constitution of India, it provides for a High Court for each state. But with the 7th Amendment of the Act of 1956, it says authorized the Parliament to establish a common High Court for 2 or more states, or 2 or more states and a union territory. For example, if you're talking about the Calcutta High Court, if you're talking about the Calcutta High Court, then what happens is with the Calcutta High Court, it used to operate as the High Court for few regions earlier. Okay, so for few regions they used to have it, but today if we talk about it, is for West Bengal's High Court as well as Andaman and Nicobar Islands High Court. Okay, so Kolkata High Court or Calcutta High Court acts as the High Court for the Union Territory of Andaman and Nicobar Islands. So if we talk about, yes, it's very obvious that High Court occupies the top position in the judicial administration of a state. Okay. So next, if we talk about how many High Courts are there in our country, yes, we have 25 High Courts as present, and 20 till 2019 if we talk about. And out of them, only 3 High Courts have jurisdiction over more than one state. Like if we talk about the High Court of Punjab, that acts as a High Court for the state of Haryana and Punjab, and also the Union Territory of what? Union Territory of Chandigarh. Okay, so 9 Union Territories we have. Delhi alone has a separate High Court. So that means Delhi High Court is the only High Court which is operating as a single High Court. Although if you're talking about Delhi status is something very different, what to say, it is a bit it's a state, but it's not a fully functional state. Okay, so as of now, the Union Territory of Jammu and Kashmir and Ladakh, they also have a common High Court. Next, let's talk about the composition of the High Court. Well, the Constitution has not specified, that is, how much should be the strength of the High Court, and it is up to the President to determine what will be the working strength of the High Court from time to time. And depending upon the workload, the President decides how many judges will be there in the, if we talk about in this particular High Court. And Article number 217, it says that the judges of a High Courts are appointed by the President. Very important. The judges of the High Court is also being done by it is also assigned by the President of India. Okay. So if you're talking about the Chief Justice is appointed by the President after the consultation with Chief Justice of India as well as the Governor of the state concerned. So just like we had the Supreme Courts, in the last class we have talked about how a Chief Justice of India is being appointed, that is based on seniority, but in the State High Court it's not the case. This is not the case of how they are following this particular thing. Okay. Okay, so let's if we are talking about the next part, what is the qualification, tenure, and the oath of this particular oath of the judges of the High Court. So if you're talking of the oath of the justice, oath, he should be, if you talk about the qualification, he should be a citizen of India first of all. He should have held a judicial office in the territory of India for around 10 years, or he should have been the advocate of a High Court or High Courts in succession for 10 years. Just like for Supreme Court, this is also the case. This is also the case for Supreme Court of India as well, that I said that in order to become the justice in Supreme Court, then what to do? Then that person has to be at least, should be a qualified to have held as a judicial office in India. Or if you're talking about what to say, if we talk about this particular person that who is also an advocate, who has been also an advocate in High Courts. So this are the things which needed to be followed when we are going for this particular thing, that is who can be a judge in the High Court. Then Constitution has not prescribed any minimum age for the appointment for a judge in the High Court, but he should be holding the office until he attains the age of 62. But remember that what happens for if you talk about Supreme Court, it was 65 years. For Supreme Court, it was 65 years, but for High Court, it is till 62 years. Okay, so this is a difference. This is a very, very important difference between the judge of a High Court and a Supreme Court. Okay, so this is all about it. Next, if we talk about the oath is being administered by the governor or the person appointed by him for this purpose. So this is all about the tenure, qualification, if we talk about, and the oath of the judge. Next, how he can be removed. Yes, he can resign from his office by writing to the president. He can also be removed from his office on the recommendation of the parliament, same as the judge of Supreme Court, and whether he vacates his office. Okay, so these are the three ways he can do it. Well, he can also be removed. Yes, he can be removed on the consideration of the consideration if the president thinks that the particular person should be removed from the judge as a judge of Supreme Court, that can be done. Okay, so this is all about our removal procedure. Now, jurisdiction and the power. Well, in the last class we had talked about a lot of things, like how this person, if we talk about that how a person, what are the Supreme Court's jurisdiction area. So Supreme Court, as we have talked about already, that they can issue writ jurisdiction where fundamental rights have been infringed. But in this case, High Court, they can also issue writs under the Article 226. And not only in such cases, but whereas there is an ordinary or legal rights has been infringed as well. And if we are talking about this, increases the jurisdiction power of the Supreme Court. And if we are talking about the other things, a High Court is primarily a court of appeal. It hears the appeal against the judgment of the subordinate courts and its functional territorial jurisdiction. It has an appellate jurisdiction for both civil and criminal matters. Hence, the appellate jurisdiction of the High Court is wider than its original jurisdiction. So, original jurisdiction, we are talking about the writ. But whereas, if we are talking about the Supreme Court, for Supreme Court, this was not the case. For Supreme Court, there was a different thing. But here, if we are talking about the appellate jurisdiction, where you can go and appeal, if we are talking about appeal for a certain things, for that you need to go to an appellate jurisdiction, which is for the state. If we talk about, it is High Court. For example, if we talk about, we go to a district court for the purpose of having our problems, or wherever we are feeling that we need to go to the court of justice, and the court has given a judgment. But if you're talking about the judgmental power, if we feel that the court has not done justice with us, then we can go to High Court for further appeal. And normally, in most of the cases, we find that High Court, the court cases are being closed. In majority of the times, it has been seen. But sometimes, definitely Supreme Court can also be approached. But for this particular reason, as everybody, criminal, civil, and everything, whatever we go for to the High Court, that actually determines that the appellate jurisdiction of the High Court is greater than its original jurisdiction. In addition to its appellate jurisdiction, there is a supervisory jurisdiction over the subordinate courts. That means Supreme Court does not have this kind of supervisory jurisdiction, but the High Courts have the supervisory jurisdiction over the subordinate courts. And if High Court thinks that administrative control needs to be tweaked and administrative control needs to be taken care of, High Court can definitely intervene into the matters of the subordinate courts. And for this, if we talk about the administrative controls and the other powers, all these things are done over here. So High Court has also this power. Okay. So with this, we come to this end of this particular chapter of High Court, and we will now go with the subordinate courts. Okay. So subordinate courts, if we talk about, which comes just below the High Court. So now it must be clear that after Supreme Court, we have got High Court, and below High Courts we have got subordinate courts. Now subordinate courts are also distributed, or there are also hierarchy in this particular thing. So now subordinate courts are under Article 235 of the Indian Constitution. The state judiciary, where it says that the state judiciary consists of a High Court and a hierarchy of subordinate courts, which are also known as the lower courts. So if you're talking about the subordinate courts, they are so called because they are under the state High Court, and there the rules and regulations for administrative purpose, state government frames the rules. You see, for Supreme Court and High Court, nobody can interfere. But for here in the subordinate courts, we see that state government interferes where? In consultation with High Court, obviously, to administer. So if you're talking about the administration purpose, this thing is being done. Okay, so state government is coming over here to subordinate, controlling the subordinate courts. So what are the constitutional provisions? Appointment of district judges. So appointment, posting and promotion of the district judges in a state are made by the governor of the state in consultation with the High Court. Now see, president is not involved over here. So governor and the High Court, the Chief Justice of the High Court, means in the most of the cases, we see that they are the person who appoint, posting regarding the posting as well as the promotion of the district judges. Okay, now for the qualification, he should not already be in service of a central or state government. Okay, so state government and central government, he should not be in service. He should have been an advocate or a pleader for 7 years. So now see, for High Court we need 10 years, for here we need 7 years. He should be recommended by the High Court for appointment for obvious reasons, because state government has directed the High Court to do this administration purpose. So now, how the district judges are appointed? Well, there is a catch over here. So for High Courts and Supreme Courts, we have seen that they are recommended people, but here they have to give an examination which is known as the Judicial Service Examination. Judicial Service Examination state, and after they qualify, then the governor of the state in consultation with the State Public Service Commission and the High Court appoints these judges. So that for this reason we see that they are basically what? They are the candidates who pass an examination. Then they can qualify after with the consultation of the governor with the State Public Service Commission and High Court, then only they are appointed as this particular thing, that is in the state provisions, constitutional provisions, if we talk about the appointment of the district judges. Now you see the structure and the jurisdiction. Broadly speaking, if we talk about, there are 3 tiers of the civil and criminal courts below the High Court. You see, there is a High Court. So let's go from the below. Now you see, there is a part which is known as civil and the criminal side. What does this mean? Civil, if you are talking about civil, not your civil engineering part. Civil means if you talk about residential disputes, land revenue dispute, revenue dispute, okay, if you're talking about fundamental rights or fundamental duties, fundamental rights, all these things comes under the part of civil proceedings. Whereas if you're talking about the criminal part, you definitely know what is a criminal part. Criminal means if you are doing a murder case, if you are doing attempt to murder case, and also the rape cases, they are all tried under the what? The criminal side. So first, whenever there is a dispute in any of the possibilities, we should not approach High Court at the beginning. We should, for civil side, we should go to Munsif's court, which is the local court, or for criminal court, we go to judicial magistrates. These are the 2 things which are at the base. Next, if we are not satisfied in the Munsif court, we go to, for civil side, we go to subordinate judge court. Whereas judicial magistrate, if you are not satisfied for the criminal side, we go to chief judicial magistrates court. And next, if we are not not satisfied, then we go to whom? We go to district courts. And here, if you talk about if you're talking about this part, here there is no difference between the civil side and the criminal side. District and the sessions court. District court deals with the civil and the sessions court deals with the criminal, but they are under single roof. And if this is not into the consideration, if you are not still happy, then only we go to the High Court. So basically, if you are talking about the hierarchy, and the top we have got Supreme Court, followed by High Court, Then we have got district and sessions judges court. Then it is divided into two parts, civil and the criminal side, which has got a subordinate judges court and the munsif's court in the civil side. And if you're talking about the criminal side, we have got chief judicial magistrates courts, and the lowest rung we have got judicial magistrates court. So this is all about our structure and the jurisdiction of the subordinate courts. So these are the hierarchies. If you talk about, these are the hierarchies which determines the subordinate courts. Okay, so I think this part is clear. Let's move on to the next part, which is another interesting issue, because why Lok Adalat came into existence at the first. Actually, before we go into this, Lok Adalat means people's court, and this is based on the Gandhian principle. And this is an alternative dispute resolution system. What happens is, we have got huge cases. Huge number of cases are there, and these cases are not solved in a day. It is being said that we still have 19 years of combined jurisdiction, which cases are still unresolved. 19 years accumulated. Means today, if we start doing, taking up all the cases, then it will take around 19 years to complete all the procedures. And for smaller petty things, Lok Adalats are being appointed. Okay, and these are alternative dispute resolution. And as we are seeing that there are so many backlog cases, so that is the reason why they have been taken together. Okay, and at times what happens, due to excessive load of cases, these petty cases are not resolved quickly because of certain high profile cases comes up. So here Lok Adalat are providing an alternative resolution or device for expeditious and inexpensive justice. Yes, this is very important thing, that they provide very inexpensive justice. Yes, so here if we are talking about this thing, that Lok Adalat, how they are performing. So here is the procedure how Lok Adalat functions. They are currently termed as a parallel courts along with this subordinate courts which we have, and this Lok Adalat is presided by a sitting or a retired judicial officer as a chairman, with two or other member, usually lawyer and a social worker. And in Lok Adalats, we don't have any hired lawyers. We don't have any hired lawyers over there. We just go there. There is a lawyer already sitting. You see, there is already a lawyer sitting. There is already a lawyer sitting. We have got a chairman who can act as a judge. And these are basically, if we talk about, these are civil cases, and petty cases are resolved in Lok Adalats. And if we are talking about the awards or the jurisdiction or the decision awarded made by the Lok Adalats, it is final, and all parties should be happy with the decision, and there is no appeal which lies against it. Means if any decision is being awarded by the Lok Adalat, that person cannot go to the High Court or any other court or Supreme Court. That person cannot go. In order to go to High Court or Supreme Court, that person needs to file a fresh case. That case cannot be transferred or that cannot be appealed in higher courts. Okay, so the first Lok Adalat, if we talk about, was held at Junagadh on March 14, 1982. Okay, so they follow their own procedure. Yes, they follow the same laws, regulations, the constitution. They follow the constitution of India. They follow the unified civil code conduct, everything they follow. But if you're talking about the evidences, summoning evidences and all, examining the witnesses, everything, that power lies with the Lok Adalat. That power lies with the Lok Adalat. Lok Adalat can do whatever they want to do, and no lawyers are involved. Lawyers are already present, and they are not charging any money, very less money, in a very inexpensive way. This particular thing can be done. In various movies also, you must have seen that there is a courtroom, there is a kind of a very small room where the people are sitting on chairs, and people go over there and start fighting or start having their disputes to be done. So Lok Adalat is a people's court. people are present over there, the parties, concerned parties are present over there. There is a judicial officer, a retired judicial officer over there as a chairman, and a social work is also there, because basically if you see about that the cases regarding family dispute, if you talk about certain kind of dispute of the property also, sometimes very small property, two poor men are fighting over there, seeing that this is my part, or they are saying this is my part. These kind of cases are conducted in the Lok Adalat. Okay, so I think this is clear to you now. Now there is another important thing which is known as National Legal Service Authority, in short known as NALSA. So what is NALSA? See, again, there are certain poor people, very very poor people, who does not have money to go to the court or hire a lawyer. It's true, because there is certain important issue which cannot be solved in Lok Adalats, but they need to go to court, they need justice, and our constitution says that justice will be provided to anyone irrespective of his class, economic section, whether he is a rich or a poor. No, we are going to provide this. In order to consider this statement which is there in the preamble of our constitution, National Legal Service Authority has been constituted. And as per Legal Authorities Act of 1997 and 2002, any person whose annual income does not exceed 9,000 is eligible for free legal aid, and this before high courts and other subordinate courts. And if the case goes to the Supreme Court, then the limit is fixed at 12,000 rupees per annum. But this limit can be increased by state government. So any person who is very poor and his annual income is up to 12,000, 9,000, or depending upon state government, that person under NALSA or National Legal Service Authority gets free legal aid. Free legal aid is being provided to the people, and this is how the weaker section of the society are being empowered with judicial activists. Okay, so judicial activists are also over there, and they are working day and night so that these people can get their due, and these poor people can get justice. So this is all about our subordinate courts. Now let's talk about the public interest litigation. Let's talk about public interest litigation. Okay, so public interest litigation has its origin in USA in the 1960s. And if you're talking about 1960s, this PIL, various, you must have heard about this thing, PIL being filed by various activists, judicial activists, for various reasons. So this origin, if we talk about origin, was in 1960. From USA it has aroused. Okay, so, and they provide legal representation to the previously unrepresented group and interests. Basically, the people who are filing PIL, they are not directly involved with the case, but they are filing a case for the interest of the public, so that the court comes to know about certain wrongdoings going on in the society. And if we are talking about judicial activism in our India, it was introduced in the year of 1980s, and Justice V.R. Krishna Iyer and Justice P.N. Bhagwati, all are the judges of Supreme Court. They had pioneered the concept of PIL, and that revolutionized the judicial activism in India. Next, if we are talking about what is the meaning of PIL. So traditional rule of locus standi. Locus standi, that means a person whose rights are infringed alone can file a petition, has been relaxed by the Supreme Courts in its recent decisions. For example, I see a group of people suffering on the road for any reasons it can be. They don't know about anything about the legalities. I can file a PIL on their behalf saying that these people need justice. So that means the locus standi, if we are talking about this particular term, that means if my rights are infringed, or if I think I am a victim over here and I should go to the court of justice to seek justice, that is relaxed. I can take a court on your behalf. And especially if we talk about various government examinations, what happens is Many a times we see that a group of people or a group of students on the behalf of the whole student community or the candidates or the aspirants, government job aspirants community, file a PIL in the court saying that the particular organization which is taking up this examination is not conducting a fair examination and we need justice regarding the same. So this is what PIL is all about. So that means, so for the interest of the majority of the sections of the people in India, so that their rights are not being infringed upon, so PIL is now being filed. So what are the sections under which a person can approach a court for filing a petition? In Supreme Court, under Article 32 of the Constitution. And mind it, 32, if you remember, this was known as the heart and soul of our Constitution. If you remember the chapter of fundamental rights, we have studied this part. Article 32 is known as the heart and soul of the Constitution, and the rights, the fundamental rights, if they are being infringed upon, then under this you can go, you can seek justice. And if you're talking about Supreme Court PIL, again, it is public interest litigation. The public are suffering and they need justice. For that, under Article 32, a person can file a petition with Supreme Court. Again, the writ jurisdiction, if you're talking about Article 226, just we have talked about, there, which is the original and the appellate jurisdiction of the High Court, we have studied now, that is also under this particular thing. And if we go to lower court, the Court of Magistrate, just as we have discussed, that can be done under Section 133 of CRPC Act, Criminal Public Courts. Okay, so this is all about our CRPC Act of Section 133. Here we can file a PIL. Now, in simple words, this is protection of the public interest in what? For example, pollution, terrorism, road safety, constructional hazards, everything. Like there is a bad road in your locality and that is creating a nuisance for every person who is commuting through that particular road. So any one of you can go to the court and file a PIL stating that this road is dangerous for public transportation. So we need something like this. Or you can see a building as a very in a dilapidated condition. That particular building needs to be repaired or that should be demolished. Then you can file a PIL. Once again, you can file a PIL in the court saying that building should be demolished. If you see that there is a terrorism, there is a lot of problem going on in a particular region. In West Bengal, we can see that there is a lot of problem going on in Northeast, or we can see in the Kashmir or in the Jammu and Kashmir region. We can file a PIL saying that for the safety and security of the nation, we need something. We need to hear about this thing. Especially if you talk about the pollution. You see, National Green Tribunal, NGT, in Delhi, in the Delhi region, they are filing PIL every year to curb pollution in NCR region. In which region? In the NCR region. They are always doing it. And public interest litigation is something which is not defined in any statute or any act, but it has been interpreted by the judge to consider whether the case stands or not. For example, if I take a PIL in front of the judge, it is up to the intelligence and the thinking of the judge whether this is a case which is actually in interest for the public or not. For example, if you are talking about which areas they focus on, whether it is a violation of the basic human rights for the poor, or whether the conduct or the conduct of the government policy is against the people or not. It may compel the municipal authorities to perform public duty, just like I said, road safety, constructional hazards, everything, they can do it. Violation of religious rights or basic fundamental rights, that can also be done for a particular section. For example, if we see that a particular section of the society, their fundamental rights are being infringed upon, then these people who are call themselves judicial activists, or even if you are also thinking that this kind of thing is happening, you may definitely go to the Court of Justice and file a PIL on behalf of these people. those who don't know about these things or those who are afraid to do so. So PIL is something which is very, it's a kind of a double-edged sword. Sometimes it can be used for you or it can be used against the society. For certain people's personal gain also sometimes PIL are being filed. We will talk about that. So now let us talk about some examples of PIL. The Bombay High Court on August 31, 2006 directed the broadcasters to give an undertaking that they will abide by the Cable Television Network Act of 1995 as well as court's order by tomorrow in view of larger public interest. That means from 1st September they wanted to do so. 1st September. What they needed? Actually, you see, Justice R.M. Lodha and Justice S.A. Bobde, the present Chief Justice of India and the former Chief Justice of India. You see, these are the people were hearing a PIL filed by Professor Pratibha Nathani of Xavier's College, alleging that the films without certifications by the Central Board for Film Certification and allowing free public exhibition are being shown on cable channels. Especially which cable channels? We are talking about the Star Network, Z Network and Sony Network. In these particular channels, certain movies were shown which did not have the censor board's permission, and these movies were creating a bad impact on the children. And for this, Professor Pratibha Nathani said in her PIL that this is creating a problem with the mentality of the students as well as the children, young children, because these films are non-certified, and whether they should be shown or not, their content is not controlled at all. So that is the reason why these channels were asked to stop showing these content in their television channels, and only the movies which has been provided the certification by CBFC, that should only be shown. So this is an example how a PIL was filed by a professor, and who saw through it, who gave their decision. Justice R.M. Lodha and S.A. Bobde, he is the present Chief Justice of India, and R.M. Lodha is the former Chief Justice of India. So these were the judges who went on to become Chief Justices in future. So we are talking about 2006 and we are now in 2020. So S.A. Bobde is now Chief Justice. R.M. Lodha was there around 4 or 5 years back. So this is about one of the most very interesting example of PIL. Now there is an abuse of PIL as well. How the PILs are being abused? You see, the PIL, basically if we talk about of late, we see that the people for their personal gain, they file PIL against a particular person, saying that he is doing certain things to many of the people over there. So these PIL is being now used as the harassment. Okay, so now with all these things, the Apex Court has given certain guidelines to govern the management and the disposals of the PILs, and abuse of PIL is slowly increasing, and that has to be stopped. Okay, so if you're talking about this particular thing, that certain things we need to take into consideration, that how we can control PIL, because PIL is something, a concept which is very new in our nation. So what can be done is that if it is a tool of harassment, then a court can fine this person, heavily fines can be given, so that this become not a public interest litigation but as a private civil litigations, and these deals could be negotiated so that they cannot be abused in PILs. Because if you talk about the PILs are basically for the public interest, whereas if you are using a public interest in a personal cause, then it is the abuse of a power which our judiciary gives us. So this is all about our PIL. Next, if we talk about, before we end, that this is a very new thing, and if you're talking about that PIL is working as an important instrument for social change, and yes, it will in future, in days to come. Well, stricter laws will be made, and there should be certain things or the guidelines on how the PIL are being controlled. Then what we will see that these particular PIL can change the society to a lot of extent. If you're talking about the welfare of the section, every section society, yes, PIL can definitely work in this particular part. It's the sword of everyone, used not only for taking justice. Those who cannot take justice, or those who think that it is difficult to take justice, then this PIL can be found. This is a very innovative thing and a legitimate instrument which will be beneficial for the developing country like India. Well, PIL till date has been used as a strategy to combat various atrocities, and institutional hierarchy and institutional problems have also been met through this PIL. And this is, as it is in a very experimental stages, there are certain deficiencies, and this slowly and slowly we can definitely overcome this particular thing, and we can move it for a better society, and slowly we will be dealing with a better technique. So thank you everyone. So this is something which I had to do, and we are already in the last fringe of this class, and I had to deal with this particular chapter also, that is local self-government. But I don't think that I would be able to take up this class with you, and what I can do is that will be providing you the notes of this particular chapter, and you go through them. If you feel, I'm asking you guys, if you feel that there is certain problems regarding, if you are not able to understand what is this thing, then I'll definitely take an extra class and keep up and explain this chapter. But before I end this class today, I'm just explaining what you need to study from this. So if you're talking about the parliamentary structure, we already know about this part. We have already talked about this thing for a quite long time, that there is a central government, there is state government, and there is a local self-government. But if you're talking about the local self-government, in rural areas, we have got Panchayat, Block Samiti and Zilla Parishad. This is a 3-tier system. Whereas in urban, we have got municipality corporation, municipalities, cantonment boards and port trusts. These are not tier system, but they are independent systems. Okay, these are independent, but these are tiers. Panchayat, Block Samitis and Zilla Parishad, these are the tiers, 3-tier system, and these are combined together to form the urban part of the local self-government. So you must have visited municipality. We have got KMC over here. We have got Calcutta Port Trust. We have got Damdam municipality or Barakpur municipalities over there. Sometimes we have got cantonment boards as well. So these are about the urban parts. And the Panchayat, you may have heard about the Panchayat elections. We have got a Gram Sabha and a Gram Panchayat. Sarpanch is over there. So these are the people who are basically dealing with the local self-government. So Panchayati Raj, if we talk about, these are, and they constituted under Article 243A to 243O. This is in the 11th schedule. Total number of subjects is 29. And this important amendment is the 73rd Constitutional Amendment Act of 1992, which came into force in April 1993. So these are the certain things which we need to follow. And 3 tiers has been recommended by Balwant Rai Mehta Committee. So these are the things which you need to follow. Oldest 3-tier panchayat is Nagur district in Rajasthan. So this is all about this. So we have, this is under state list, and Article 40 of DPSP deals with, they have already given a concept of Panchayati Raj in India. Okay, so this is, we have already talked about this. So district level we have a Zilla Parishad, block level we have Panchayat Samiti, and village level we have Gram Panchayat. So this is about these things. So as you see, so West Bengal and all these things, this is the number of West Bengal we have. So district magistrates 20, now it is 23. Sorry, it is this old data, it is 23. BDO we have got 341 BDOs, and Gram Panchayat Pradhan we have got 3354. So these many Gram Panchayats or Sarpanch we have in our state of West Bengal. So this is all about, I will be sharing the slide with you people, that which are the articles. These are the things which you need to follow. Very, very important things. Who can be a part of the panchayat system. See here the differences, 21 years, where we have seen 25 and 30 years we have seen on the most of the cases, but here we have got 21 years, and he has to be resident of the particular area, not from outside he cannot come. Okay, so the important committee, if we talk about, we have got a Balwant Rai Mehta committee which was established in 1957, which for the first time had this Panchayati Raj system established. Okay, so this has been established by Balwant Rai Mehta committee, and this is the person who is Balwant Rai Mehta. Okay, and there was also an Ashok Mehta committee which said that the 3-tier system should be replaced with 2-tier system, that is Zilla Parishad and the Mandal Panchayat, and Zilla Parishad should be the executive body, and the Zilla, and these are the things which we have to follow. So in the book I have already shared with you guys, please go through the book so that you can basically understand this. But I am repeatedly telling you once again, if you have any sort of problem in understanding this chapter, definitely get back to me. Then I will be arranging a special class for you people. Okay, so I will be giving a special class to you guys. Okay, so there are various committees, LM Singhvi and all these things. These committees are there. So go through this slide. I will be sharing these slides with you people so that you can have a look into it. So thank you for today. So I will be stopping here and this is our last class before the examinations, I believe. So if you need an extra class, I am repeatedly telling you, definitely you ask me, I will take an extra class. Okay. And next, if we talk about, we also have come to this end of the module 3 and module 4 also we have completed approximately in a hasty manner. So if you have any doubts, you can get back to me anytime. You have my phone number, you have my mail IDs, so you can definitely mail me or text me on WhatsApp. Okay, so thank you guys, thank you very much, and wish you a very happy Diwali. Stay safe, stay healthy. All the best for your upcoming semester examinations, and hopefully we will meet again. And it is a very unfortunate situation that we could not meet in a physical classroom. Otherwise, we would have loved to have a lot of debates in this particular subject, because this subject is a very, very interesting thing, and we can have had a lot of debates in this subject. So guys, we believe in a healthy manner of studying, and as well as staying point of time, we need to stay safe because of this COVID-19 pandemic situation. So guys, stay safe, stay healthy. We will meet very soon in a physical classroom. Till then, happy learning. Thank you. And once again, I wish you all very happy Diwali. Thank you very much.